Hello and welcome to our second session of Lunchtime Live, brought to you by the Office of the Commissioner representing employers at the Texas Workforce Commission. My name is Valissa Chapa and I am one of 4 staff attorneys in the Employer Commissioner's Office. And today we are going to be covering a variety of employment law topics that are very useful for employers, starting with COVID-19 leave-related laws, UI claims and chargeback for employers, privacy issues in the workplace, and Payroll Tax 101. After that, we will do a Q&A session to answer some questions that were submitted from folks who registered for this session. So I'm going to go ahead and share my screen. We have a lot of information to get into today, so let's go ahead and get started. A few housekeeping items that I wanted to cover while I'm sharing my screen. First of all, this is being recorded and it will be available for viewers after the webinar. So if you're missing a portion or you'd like other folks to see it, there are ways to get that to them. Also, if you're like me and you like to take pictures of relevant slides as they go through, you might want to keep your camera out to take photos. And finally, there is no continuing education credit or units available for these webinars, but we will continue offering that once we revert back to our standard in-person conferences where we travel around the state. So as I stated, we're going to start with COVID-19 paid leave related laws, and my slides should be up and ready for view, so let's get started. So this is a continuation of the medical leave related laws presentation that I gave on September 17th, and if you'd like to view it, the link is there below. There's also a bunch of frequently asked questions that employers have been asking, and so we have that as well, and we are updating that document as more questions and answers are being formulated. So here is the basic list of medical leave laws available or that apply to employers. In the last session on September 17th, I covered the first 4. So the ADA, FMLA, PDA, and workers' comp. I covered those 4 pieces on September 17th. The last 2 I touched on a little bit, but I didn't really get into because it's a lot different. So that's what we're focusing on today in part 2, the Families First Coronavirus Response Act. We're going to cover that and the 2 pieces of law that fall underneath that FFCRA umbrella. So what's the difference between the 9/17 presentation and today? Well, part 1 addressed medical leave related laws, paid or unpaid, that were in effect long before COVID-19. Those have always been in place. Part 2 today is going to address paid leave related laws, not necessarily medical, that are in place specifically as a result of the COVID-19 pandemic. So today's focus is going to be the Families First Coronavirus Response Act, or the FFCRA. So what is it? This is a new federal law, and it requires employers to provide job-protected paid leave to employees who qualify for it. So this is, and in my understanding, it's one of the first time that a federal law has ever mandated paid leave, and this is in place just because of COVID-19. So here are the basics. You have the Families First Coronavirus Response Act, the umbrella. Underneath that law, there's 2 laws that we're going to talk about today. The Emergency Paid Sick Leave Act, or EPSLA, and the Emergency Family and Medical Leave Expansion Act, the EFM-LEA. Both of these laws became effective April 1st, and they expire December 31st of this year. They're also a one-time use only. So what I mean by that is each law, if it's triggered, requires you to pay so much for a certain period of time. And once the leave has been exhausted by that employee, it does not reset. It's a one and done kind of situation. Also, this paid leave is in addition to any other right or benefit. So what I mean by that is if you have paid leave in your business already, PTO, whether it be sick or vacation or just PTO in general, this is in addition to that. You can't use the PTO that your company gave the employee to cover this FFCRA. This is an additional piece of paid leave. And finally, this is enforced by the Department of Labor. So if you have questions about this, and of course situations are different, Department of Labor is going to be your primary source for that information. So let's start with thresholds for coverage. The FFCRA umbrella, who does it apply to? Well, if you're a private employer with under 500, it applies. That also includes nonprofits, and of course it also includes public employers. So whenever someone is needing leave and you have to grant it, it all starts with the idea of, are they your employee? Do they count as an employee under the FFCRA? So first of all, part-time and full-time employees do count. Doesn't matter if they're part-time or full-time. Also, employees of integrated enterprises. And what that really means is if you are getting employees through a temporary staffing firm, a temporary help firm, or if you are a joint employer, then they could count as your employee. Also, it does not include independent contractors or employees working outside of the US territories, or DC. And finally, when do you start the count as far as how many employees you have? It starts when the employee leave is initiated. So let's talk about PTO and FFCRA a little bit. So earlier I mentioned that FFCRA paid leave is in addition to whatever you're already offering them under your paid time off policy. But not only that, in what order do you pay them in? You can't require employees to drain their PTO before providing FFCRA pay. The order usually goes FFCRA, and then if they run out of that, PTO if they have that available. Now let's talk about health insurance. This is pretty simple. Maintain health insurance. Employers, if they're on FFCRA leave, you're protecting their job, keep their health insurance going, and the employee is still responsible for their portion of the insurance that was agreed to initially with the company. Now, what about business closures? This is a new issue because there's been some issues with a particular court case involving the FFCRA. So according to the most recent guidance from the Department of Labor, as of today, the FFCRA applies when work is actually available. So what we mean by that is if you have an employee who is out on FFCRA leave and the business has to shut down completely, economic issues, right? Perhaps they can't make payroll, then the FFCRA entitlement ends. But the employer should always be aware of retaliation. You certainly don't want to let someone go and argue the business closure is why you stopped their FFCRA pay, when in reality it was for other reasons. But the idea is if there's no work for them to perform for the business, then the business is closed, either because it's a temporary layoff, otherwise known as a furlough, with a return to work date, or just a permanent shutdown. FFCRA leave is not applicable because there's no work for them to actually do for the business. Now let's do the breakdown again. The FFCRA has two laws within it that we're going to discuss. The first, the Emergency Paid Sick Leave Act, EPSLA, and then Emergency Family and Medical Leave Expansion Act. So I'm going to break down each of those laws separately to let you know how they work. So let's start with the first one. I'm just going to call it EPSLA just to be short and sweet. So that law, there are 6 qualifying COVID-19 related reasons that trigger this law. So if one of those 6 conditions is met by the employee, you are required to pay them. And the amount that you pay them is dependent upon their schedule. Are they full-time or part-time? So there is a breakdown for that. Under EPSLA, all employees are eligible regardless of tenure. They can work for you for half a day and they qualify. Of course, you also want to continue with their health insurance. And this law, EPSLA, it doesn't apply if they can telework, because the concept of this law is that they can't continue working for you because of one of these 6 reasons. And you can see the first half and the second half are going to be different. But if one of these 6 reasons exists, you are required as an employer to provide paid leave under EPSLA. So let's break down these 6 factors. The first 3 is how I'm going to separate it. So as you can see, if an employee is subject to a local quarantine or isolation order, and that includes shelter in place or stay at home orders, then that triggers EPSLA. Maybe they've been advised by a healthcare provider to self-quarantine, or maybe they're having COVID-19 symptoms and they're seeking a diagnosis. If any one of these 3 conditions exist for the employee, then the employee is entitled to up to 80 hours of pay at 100% of their regular rate of pay. Either at their rate or the minimum wage, whichever's higher, up to $511 a day. So if one of these 3 conditions exists, you're required to pay up to 80 hours at 100% of their regular rate of pay. The other 3 reasons are a bit different. These have to do more with, the first one is caring for someone who was told to self-quarantine. They can't care for themselves. Maybe you're caring for a child, or the employee is caring for a child whose school or place of care is closed, or the provider's unavailable, or the final one, other substantially similar conditions. Number 6 on this is sort of a catch-all. It happens often with laws. You know, we can't think, or when folks are writing laws, there's sometimes pieces that are not thought of because there's just too many variations of a situation. So number 6 is the catch-all language. 4 and 5 tend to be the more relevant ones that people are looking at. So these are different from the first 3 because the first 3 are paid at 100%. The last 3 are paid at 2/3 the employee's regular rate of pay, up to $200 per day. Now, the interesting piece here that I wanted to point out is number 5. Number 5 has to do with an employee who's caring for their child where the school or place of care is closed or the provider's unavailable. That ties in to the other law under the FFCRA umbrella, the Emergency Family and Medical Leave Expansion Act, EFM-LEA. Now, this law is the separate one under FFCRA, but this is a little easier. There's only one reason for leave under this law. This is only for employees who can't work or telework because they have to care for their own child, or the school is closed and they have to provide care, or maybe the child care provider is unavailable. So this EFM-LEA law is very similar to the language under number 5 under EPSLA. They tie in together, and that's important when we're looking at how the EFM-LEA works. Here's the deal. EFM-LEA provides up to 12 work weeks of leave. The initial 2 weeks of those 12 are unpaid, and the twist is this. To cover that time, the employee can use their own paid time off they have, because remember, under the EFM-LEA, this is paid at 2/3 the regular rate of pay, as is number 5 under EPSLA, 2/3 regular rate. So it's consistent in that sense, but the employee can use PTO, which would be 100% for those 2 weeks if they wanted to, or they can take their first 2 unpaid weeks of EFM-LEA and use their 2 weeks of paid leave under EPSLA. So that's why the first 2 weeks of 12 under EFM-LEA are unpaid. They can use their own paid time off, or the 80 hours that's available to them under EPSLA to cover that time. And then the remainder of the 10 weeks are paid at 2/3. And then, no more than 200 a day or 10,000 in total. So the difference with this law for eligibility is under the first law that we talked about with these 6 factors, for the EPSLA, they could work for you for just a few minutes. If you're their employee, if they're your employee, they get this. They can get this time off under this law. But under EFM-LEA, they need to have been employed for the employer for at least 30 calendar days before they can be eligible. So that's a difference, but there are more similarities. It can be part-time or full-time. It applies to private employers with less than 500, also to some public agencies. The last bit here is the interesting interplay between this law and the Family Medical Leave Act. If you have 50 or more employees, then you might be familiar with the Family Medical Leave Act, and that allows employees 12 weeks of leave, doesn't have to be paid, for qualifying conditions. So does this add 12 weeks on top of the FMLA 12 weeks? No, it does not. This is just a new reason for leave. We're not going to stack the 12 and 12. They still have 12 weeks of leave, period, and they can use this reason of inadequate childcare as one of those reasons to use this time. So let's talk a little bit about remote learning. As you can tell from the prior slides, if you don't have adequate childcare because the school is closed, you could qualify for paid leave under both laws within the FFCRA umbrella. So what does it mean by closed? Well, if it's only remote learning because the physical building is shut down, the school is closed for purposes of this law. If it's optional, some schools are opening their physical building, but they're giving students the option to do remote learning, the school is open. And sometimes there's a hybrid. On some days, the school is physically open. On others, they only do remote learning. So in that sense, it's open on some days and closed on others. So when we're looking at, hey, is the school closed for purposes of these laws? If the physical building is closed for students, the school is closed under this law, and only under this law is what I'm talking about. So let's talk about required notice. You have to give required notice to your employees about the FFCRA. And so if you wanted to take a picture of this, but it's even easier to just go on the DOL website. This poster tells employees what their rights are under the FFCRA, and you got to post it. So here is an example of what it looks like. And again, this is from the Department of Labor, and it tells them about all of their entitlements to leave under these laws. And again, it's mandatory to post this. So you can do it in a conspicuous place in the premises, but if you can't do that because folks, maybe some or all are working remote, share via email, direct mail, or the company intranet. You don't have to post it in other languages, but you absolutely can, and the Department of Labor now has it in multiple languages. And of course, you don't need to share this with individuals who are laid off or job applicants, because under this law, neither one of them are your employees in that moment. There's another interesting document here at the bottom, quick benefit tips from the Department of Labor. I don't think you need to post this, but I think you should if you can, just because it's very clear. It breaks it down to something a little more simple, and your employees can get a better idea as to how this all operates and what they could be entitled to. So you can consider that as well. So record keeping. Record keeping is really important, and it's required under the FFCRA, and there's different records you keep depending on the type of request. So here's the first slide that tells you what you've got to have every time for the basics: the name of the employee, the date the leave is requested, and the reason for leave. You also need a statement from the employee that they can't work because of that reason, and they need to provide it as soon as practicable. So number one, you got to have those basics. It sounds obvious, but I state it because it's actually required. Then there's record keeping requirements depending on the type of request. So if they are subject to a quarantine or isolation order, or they're caring for someone who's subject to that, you need to document the name of the government entity that issued the order. I know everyone knows, right? It's kind of an obvious thing, but there's no reason not to put it in there. It is required. Also, if they are requesting leave because of a healthcare provider telling them to stay home, or they need to care for someone who is quarantining, you want the name of the healthcare provider who gave that information to you or to the employee. And then finally, if they're requesting leave to care for one of their children, then you need to document the name of the child, the name of the school or child care provider, and a statement from the employee that there's no one else suitable to care for the child. So you have to have all of these things, not only because it's required by the FFCRA, but also for this reason: tax credits. You can get a tax credit for 100% of the qualified leave wages you pay under the FFCRA. Now, it only covers qualifying wages. So what I mean by that is, for the childcare issues, you're required to pay 2/3 at the employee's regular rate. Some employers want to pay them 100%. Can you do that? Yes, absolutely. You can pay them that extra 25%, but the tax credit will only give you 75% of that. Or rather 2/3, I'm sorry, 2/3 is what you'll get a tax credit for, but not for the 100%. And those tax credits also extend to amounts paid or incurred to maintain health insurance coverage. So to get the credit, you need to keep this documentation because it substantiates your need to pay the employee under the FFCRA. So there's you definitely need to contact the IRS on the procedures to claim the credit. Get it straight from the federal agency that regulates those things. And I just did a quick online search for IRS COVID-19 tax credit, and I found this great page from the IRS that breaks it all down and has some info. So I do encourage you to take a look at that as well. So there is some relief on the back end for employers who have to pay under this law. Now, a few exemptions: small business exemption. So if you are an employer who has under 50 employees and the employee's leave is to care for a child, and that would jeopardize business viability, you may be exempt from the FFCRA. But of course, how do you determine whether business viability is jeopardized? What does that mean? Department of Labor has a bunch of Q&A documents, and questions 58 and 59 define what those requirements are for an employer to successfully argue that business viability is jeopardized. So with this exemption, do you apply for it? You do not. You don't send anything to the Department of Labor in advance. This is just something you document for yourself. There's no application and you don't need to supply it to Department of Labor at the time. What will happen is if the complaint is made to the Department of Labor and they investigate, then they would be contacting the employer, and that's the time where the employer can mention the exemption and provide their documentation to support it. So don't send anything to Department of Labor about the exemption. It's only relevant if an issue has been raised. So special exclusions. Healthcare providers and emergency responders are excluded from the FFCRA. There's a lot of confusion with healthcare providers, so I'm going to take a minute about this. When it comes to healthcare providers, you focus on the employee's role, not on the employer's role. We get a lot of questions from healthcare facilities asking, are we exempt as a whole? I would say, in my opinion, and please note, I don't work for the Department of Labor, but I, in my opinion, do believe that it is not based on what the actual employer's business is. It's more dependent on the employee's job, because we look at it like this. If you're a healthcare provider, you very likely have doctors, nurses, other healthcare professional, medical technicians. They're excluded from the FFCRA, but there are also folks who maybe don't provide direct care to a patient, like a laboratory technician. Laboratory techs are also so integrated into patient care that they are considered to be healthcare providers. So it's not an exhaustive list. The employer really has to look at the role of the employee, and if there are doubts, contact the Department of Labor. Now, just because the business is in healthcare does not mean that all employees are excluded. That's the trick. You could be a healthcare service or business, but your IT professionals, your HR staff, your billers, your consultants, record managers, they are not considered healthcare providers under FFCRA, which would mean they are eligible for that paid leave. So that's what I mean when I say it's not just about what the employer's business is. You have to look at the actual role of the employee, because there are some folks who work for healthcare businesses who do not perform the patient care or are integrated into the process such that they're considered a healthcare provider. So please keep that in mind, and of course, contact the Department of Labor. Another exclusion is emergency responders. This includes but not limited to, so this isn't very common, but here's your sort of mini master list of all of the individuals who are considered emergency responders and are excluded from FFCRA. Now, I mentioned the Department of Labor frequently asked questions. I cannot say enough about this. They are updating it as new issues come in. DOL.gov gives you lots of good information. That's where this material is from. And so if you have questions, because of course situations get tricky, here is a huge list of over 100 questions on different circumstances. So I do encourage you to go to DOL.gov. And just to show you all real quick how to get there, DOL.gov, you scroll down. You click on this link, coronavirus-related paid family and medical and paid sick leave. There is so much good information here for you. Online tools to determine eligibility, for example, really easy. And of course, the Q&A and fact sheets and all that good stuff. So I just wanted to quickly show people how to access that. So that is it for my presentation today. I am now going to turn it over to my colleague, Elsa Ramos, who is an attorney in the Employer Commissioner's Office at the Texas Workforce Commission, and she is going to be talking about unemployment claims and chargeback protection. Elsa?
Hey, thanks guys. I'm hoping you can hear me, and I'm hoping soon you can see me. I'm going to be trying to share my screen. Here we go. So unless I hear otherwise, I'm going to trust that you can see my screen and see me, or at least hear me, because that's what's important. What I'm going to be talking about today. I don't have your screen, Elsa. And I heard something about my screen. I'm sorry.
I don't have your screen.
You can't see my screen. And this, folks, is what happens when we go live. Melissa, did you stop sharing? Yes?
Yes, I did.
Okay.
Yeah, that's starting at row 2.
And folks, we had it just a little while ago. Yes, we did. Queue content. Can you see it now?
There it is. Yes, Elsa.
Great. Sorry about that, folks. Not the high-tech person in the group. Okay, so there is my screen. Let's make it big. All right, so I am here to talk to you about your chargeback liability employers. So let me start my timer. And why is that? Because you employers, as tax-paying employers and as reimbursing employers, you pay for the unemployment system. And because of that, that money comes out of your pocket. And it's really important to know how the system works. And we're always surprised when we go to our conferences and when we take calls from employers, how many employers who have been participating and paying into the system don't understand how the system works. So we're going to be here to show you how chargebacks affect you and if you're going to be one of the people in that, target of chargeback. So getting started. 1, 2, on. There we go. So that's me. So we're going to cover the basics. Like I said, I've talked to employers, I kid you not, who have called me and said, I have been an employer for 40 years. And can you tell me how the chargebacks work or how unemployment works? So we're going to make sure that nobody gets left behind. So true or false, really quick here. Answer in your head or out loud if you want. That's fine. Unemployment benefits provide lost wages to claimants, what the job used to pay. So basically, unemployment benefits pay you what the job used to pay. True or false? That's false. Okay. Unemployment benefits do not pay you what the job used to pay, which is why during this COVID time, we got a lot of folks wanting to know, hey, my wages were reduced. They're paying me 25% less, but I'm still working my hours. Can I file for unemployment? Or employers saying we're reducing the wages of our employees. Can they file for unemployment? A reduction in wages alone is not going to be a job separation for purposes of unemployment benefits. There needs to be either you stop work altogether or a reduction in hours. That's a job separation for unemployment purposes. The other thing is that best case scenario, unemployment benefits pay you about half of what the job was paying you. Okay, so here's the minimum, $69 a week, and the maximum, $521 a week of the regular state unemployment benefits. This does not take into account the federal dollars, the extra $600, the extra $300 that we've heard about recently. And starting today, October 1st, those amounts are going up to $70 minimum or $535 per week. So it does not pay you what your job used to pay. True or false? Question number 2, deduction from employees' wages pay for the unemployment system. A lot of people think that that's the case, and we get appeals from claimants. Again, these are the people who file claims. We get appeals from claimants all the time who say, I've paid into the system for 15 years. I deserve my benefits. That's false. You employers, and if any of you are business owners, you know this already. And if you're not, you may not know this, but the unemployment system is paid for basically 100% by employer taxes. So you employers, you pay into the system to make sure that these benefits are available in case someone's out of work under the conditions that we have. So the bad news is you have to pay taxes, employers, but the good news is that you only pay the tax on the first $9,000 of employees' wages. Now you might still be saying, yeah, but I still have to pay the tax. What's the great news there? The thing is that each state is different. So if you were an employer in the state of Washington, for example, you'd have to pay the unemployment tax on the first $52,700 of employees' wages. And that is a lot greater than the $9,000 in Texas. And I can't help it because that makes me say that makes Texas greater than Washington. You can clap there in your homes or your offices. So true or false? TWC provides temporary income replacement assistance to people based on their need. Common misconception. This one is also false. Unemployment benefits are not there to provide people with benefits because they need them. Because, think about it, right? You lose your job. Are you going to need more money? Absolutely. But it's not based on that. There may be other benefit systems out there that are based on need, but unemployment is not one of them. It is based on fault. In order to get unemployment benefits, you have to be out of work through no fault of your own. So what does that mean? It means that if you voluntarily left your last work while work was still available for a reason that's not good cause connected with the work, you're going to be considered at fault employee for the job separation and be disqualified. If you're discharged for a reason that's misconduct connected with the work, you are going to be at fault for the job separation and be disqualified from benefits. So in broad strokes, this is just an insurance plan. It's in the name, unemployment insurance compensation. So if you think about it like car insurance, and we all understand what that is, this is Texas, we drive everywhere, right? You pay a premium to be covered in case someone makes a claim against you. So you rear end someone at a stoplight, if you're insured, you don't have to pay out of pocket for the repairs to the other person's car. Insurance company takes care of it. Unemployment system is very much like that. That tax that taxed employers pay, that's like the premium. It goes into this big fund of money, the trust fund that's administered by the Texas Workforce Commission. And then if someone's out of work through no fault of their own, one of your employees, you don't have to write us a check for those benefits. It comes out of the insurance fund, okay? But then like those benefits could be charged back to the employer. So what does chargeback mean? Because that means like I'm gonna get a bill. That's what it sounds like, right? Taxed employers, although it sounds like a bill, it's not a bill. Benefits that are charged back to the employer are now used in the complex mathematical formula that calculates your unemployment tax rate for the following 3 years, counted 3 years, not just the next year. And that's why chargebacks are important, right? So just like your premium goes up after a car accident, what do you think happens to your tax rate if benefits are charged back to you? You can say it. Whoops. There we go. Your tax rate goes up. And I know all you business owners out there don't want to pay more in taxes than you absolutely need to. Now, reimbursing employers, here's a word for you. So if you're a governmental employer or a nonprofit who has chosen to be a reimbursing employer, you do get a bill. So that's the bad news for you. You don't get an increase in your tax rate. You get a bill dollar for your share of unemployment benefits. Now, for both reimbursing and taxed employers, not all benefits are going to be either charged back or billed to you. It all really depends on a period of time known as the base period. And here you have the definition, the first 4 of the last 5 completed calendar quarters prior to the claim. That's a lot of words. I prefer to show what the base period looks like with a diagram. So again, employers, you know you file quarterly reports every quarter where you report wages and pay the tax. We measure from those quarters because that's the information that we have. So you take the quarter when someone files a claim, count back 5, take the first 4. That's one way. I prefer looking at it this way. The quarter when the claim was filed and the quarter right before don't count. The 4 quarters before that, right there, those make up the base period of the claim. So if you're an employer who reported wages during those 4 quarters, you've crossed over into another dimension. I know, a dimension not of sight, not of sound, not of imagination. Welcome to the chargeback zone. And please know that's what I call it. That's not what TWC calls it. So if you call up wanting to have, with a question about the base period, don't say I'm here about the chargeback zone. It's called the base period. So why is it important? Because if you reported wages during those blue quarters, you could be charged back or billed for benefits. If you reported wages in those yellow quarters or in quarters that don't even show up here, then there is no financial liability for you, not even the potential of that. So that's why it's important to know and understand the base period. And here is the diagram from our webpage of what the base period looks like for a claim in any of the 4 quarters. Okay, now for COVID, what are we doing with COVID separations? And you may have heard this months ago when we got our guidance. For job separations that are resulting from the COVID-19 natural disaster, taxed employers are eligible for chargeback protection, which means that claims that result from COVID would not be charged back to the employer. So that's great. But how do you do that? Because please understand, this is not automatic. We don't just take all the claims during this period of time and say, let's protect all of the employers. There are still many claims that are not related to COVID, right? So we still send you notice, employer, because if I was working for you and you had to shut down because of COVID, I'm going to file a claim and I'm going to say, hey, I used to work for Acme Company, which is yours. You're going to get written notice of that claim and you have the opportunity to protest or give us information on that claim. And I suggest you do that, because if you just ignore that, and because of some way that the claim was filed or information that we didn't get, we don't code that claim as a COVID natural disaster claim, you could end up being charged back. So you still need to respond. Don't ignore these notices. This is the notice of claim that you get when you're the last employer. Not sure if you can see that, but this is straight out of the form. How do you respond? You have 4 ways to respond. We really do try to make it easy. I know it doesn't seem like it, but we do. You can respond by mail, by phone, by fax, by internet. It does not have to be in writing. You can call us up and say, you know, hey, Elsa was laid off because of COVID. Or you can say, no, Elsa was discharged because she was stealing from me, or some other kind act of misconduct. So make sure and respond. The deadline is short. It's 14 days from the date that we mail you the document, not from the date you receive it. So it is important to be timely. Here's one thing we've been seeing a lot. Employers who are calling us and contacting us and saying, hey, why am I being charged? It was related to COVID. The job separation was COVID related. Here's what employers need to do. When you respond to the claim, if you do it online, especially, there's a little drop-down menu. You want to choose that the job separation resulted from the COVID-19 natural disaster. And if your employees file a claim, and if they haven't already, and you know, I know that we're going kind of starts and stops on this and things are changing all the time, but if one of your employees who hasn't filed a claim files one and it's related to COVID, they need to tell us and they need to choose if they do it online from the drop-down menu, or if they speak to someone, they need to tell us it's related to COVID. A lot of employers receive chargeback notices because the employee said temporary layoff. Now that's not wrong. It's not inaccurate, because when COVID happened, a lot of the layoffs, we expected all our employees to return back to work. So that's what happened. But sorry about this, guys. I lost my content, my PowerPoint. So here we go. COVID related. So you want your employees, sorry about that, you want your employees to choose COVID, and you want to choose COVID as well. So if you file a late response to the claim, you lose appeal rights. So it's really important to be timely, incredibly important, because you don't want to lose the appeal rights, like I said, in case something happens with your claim and you end up with a chargeback that you shouldn't end up with. Now, I told you that if you report wages in any of these blue quarters, you could be charged back for benefits. That notice of claim I just showed you is for employers who are the last employer. What we're also finding is a lot of employers are being surprised by notices of maximum potential chargeback. Because remember, you don't have to be the last employer. As long as you filed a claim in one of those quarters, you could be charged back. And I was told you can't see my screen. I'm not sure what to do about that, guys. So if you can see me, okay, then listen to my words, all right? And we'll make these slides available. Notice a potential chargeback really frightens employers, because all you see when you get that is maximum chargeback, right? And then you start thinking, well, that person quit a year ago. Why are they filing a claim and naming me? They're not naming you in the claim. They're not. But this is something, because you're in that base period, we sent the notices of the potential chargeback to all of those employers that reported wages. Okay, so you're going to want to respond. The deadline for responding to notices of potential chargeback are 30 days from the date it was mailed, not 14 from the date of the claim, because we understand if this person worked for you a year ago, you might need to look up those records. So you get 30 days from the date it was mailed. This one cannot be responded to in person, so you do need to respond in writing. So the internet, fax, or mail in this case. And like with the notice of claim, if you file a late response to this, you're going to be charged. Okay, you can appeal that, but I can't say which way that's going to go. It's really important to be timely for that. You can't see my screen, so you can't see a picture of me. Back when I worked in a nursing home prior to finishing law school, I worked in a nursing home for 6 years, and there was an assistant director of nurses. Her name was Mary White. She's still alive, she's retired, but Mary White used to say something all the time that stuck with me. It was basically, if it's not written down, it didn't happen, right? You all know that you need to document everything that you do. If it's a COVID-related job separation, document that, because if it's not written down, it didn't happen. If somebody quits you and it's not COVID-related, we're getting a lot of those complaints as well. You know, my employee saying it's COVID-related, it's not. She quit for no reason that I'm aware of. I have no idea what happened. Make sure if you have a job separation, document everything that you know about that as to what happened. Take statements from your employees. If it's misconduct related, make sure that you're documenting the bad behavior, the warnings, etc., that happened there if it's not COVID related. If you receive something late from us, if you receive some kind of notice and it's late, document that. When did you get it? Who gets the mail? Were you checking your mail every day? If you're going to submit something late because you received it late, document what you did. If you fax something, keep a fax confirmation. Because remember, if it's not written down, it didn't happen. I'm repeating it many times because I hear Mary White's voice in my head, so I want you to be able to hear my voice in your head about this. So, one moment. I am getting some notices about how to possibly share my screen. And again, apologize, everybody. I am not the technical wizard, and we're all working remotely. I pushed the share button. I am trying. So, I'm not sure if you can see my screen or can see me. In these last few minutes that I have, I want to tell you why the chargeback matters. Again, you business owners, you already know this. Those of you who work for businesses and you're responsible for handling job separations and responding to claims, this is why it's important. The tax rates for unemployment. The minimum tax rate, not so horrible, but at the 6.31, which was the highest tax rate, the maximum tax rate we had for 2020, that meant that you were paying $567.90 for each employee per year. So remembering that chargebacks can affect you for 3 years, that means that that can start to add up if you don't handle job separations correctly, or if you don't take advantage of chargeback protection that is available, right? So this is why it matters. You reimbursing employers, you get billed, remember, under the old weekly benefit amounts that we had, you could be billed up to $13,546 for an employee. I realize that many of you nonprofits who are reimbursing employers do not figure for this in your budgets, and you're not prepared to pay thousands and thousands of dollars, okay? And because the weekly benefit amounts have gone up, you could be billed even more after October 1st, after today, with the benefit amounts. So you guys, you don't get the same chargeback protection for the COVID disaster as the taxed employers, but there is some relief for reimbursing employers, again, governmental and some of you nonprofits, there is some relief for you under the CARES Act. And we're going to be talking about that at our next Lunchtime Live on October 15th. So join us, reimbursing employers, on October 15th and 2 Thursdays from today to find out what relief is available for you. And with that, I am done and will be then hopefully passing this over to Tommy, who will be making a presentation after me.
It's definitely getting more sense of like, I know what future I can feel it now. There's no reason for you to get a smaller laptop.
Can everybody see? Very
Yes.
good.
Yes.
All right. Okay, hopefully my voice is coming through okay. I'm hearing a little bit of echo, but hopefully everybody can hear me okay.
You're good, Tommy.
During this next segment, I'd like to hit on some of the most important workplace privacy issues that come up. Contact information for Commissioner Demerson's office is up here on the screen. The online version of our book, the Texas Guidebook for Employers, otherwise known as Especially for Texas Employers, is this web address that is the third line from the bottom. And we have a web app that will work on any mobile device. At the address, the second line from the bottom. And Commissioner Demerson's toll-free number for employers is the bottom line there, that 800 number. And that's for any employer to call if you have a question about a claim or some kind of employment-related issue in your workforce. Now, talking about privacy issues in the workplace, I think a good starting point is just to keep in mind that employee information and information about your former employees as well is confidential. It's private. People have privacy rights. They have a right to confidentiality. And basically, if you start off with the outlook that employee information is confidential and should not be released, you'll probably do pretty well. You might end up releasing that information at some point, but that'll be because maybe a law requires it, or it's something that has been authorized by the employee or authorized by the agency in connection with an unemployment claim. But a good starting point is don't release the information because, basically require whoever is asking for the information to prove that they have a right to know it. That's a good starting point. To that end, it's a good idea to have all information requests go through a central information office or a person who is designated to be some kind of a document release or information release officer, personnel file information officer, somebody who is trained in privacy issues. The Public Information Act is fairly well known, otherwise known as the Open Records Act. That doesn't apply to private employment situations. That applies to government agencies, local, regional, and state government agencies in Texas. And basically, citizens have the right to request documents from the government. That does not include any right of employees to request copies of their personnel file or company documents from the company. Basically, those are company information, company property, and the Open Records Act has nothing to do with that. Now, if you, of course, are a public sector employer, you're covered by the Open Records Act, and the Open Records Act requires your agency, your city government, county government, district, or state agency to release personnel file information to the employee. If they request copies of their own personnel file, you need to release that to them under the Open Records Act because they're your employee and they have a right to see their personnel file if they are working for the government. But that does not apply in the private sector. Some information cannot be released to anybody but the employee themselves, such as social security numbers, medical information from doctors and hospitals, and also anything that if it were released, it would constitute the offense of invasion of privacy. And that's usually associated with information that is so personal, so intimate in detail and so on, that the release of it would offend a reasonable person. So that is something to keep in mind if you're a government employer. Focusing on personnel files, a common question is, do we have to release copies of somebody's personnel file to the employee if they ask for it? The answer is no. If you're a private sector employer, those personnel file documents are your property. You have to decide what should happen with those, and you don't have to release copies. Of course, most companies release copies, under the supervision of an HR employee or something like that. Most companies have a policy whereby they will allow supervised viewing of a personnel file in the presence of an HR person. Copies can be made. It's okay to charge for copies. Most companies charge 10 cents a page, but it's really up to the company. That's not required. It's just that most companies do that. But whatever you do, protect personnel file information from unauthorized disclosure. We recommend having different files for different purposes. The reason is that if a government agency, for example, wants to come in and audit your company for I-9 compliance with the immigration laws, making sure that people are authorized to work in the United States, you don't particularly want the I-9 auditor from the United States Customs and Immigration Services Bureau to be looking through your wage and hour records or through your grievance or investigation files or medical information files or OSHA records. You just want them to see the I-9 records. So keep I-9 information in an I-9 file, workplace safety and health and accident-related information in an OSHA file, grievance and investigation information in a grievances and investigation file, and general purpose documents like job applications and performance evaluations in a general purpose file. Payroll information could go into a payroll file, but keep the separate files separate, and each type of file should have controlled access. Only people who have a job-related need to know should ever be looking at any of those files. Release personnel file information to prospective new employers only if the ex-employee authorizes it in writing. That's not a law. It's a best practice. It's a strong recommendation. The reason is that it's possible, of course, for somebody to feel that they may have been defamed by an employer telling the truth about their former employee. If a job reference request comes in. Texas law is pretty tough on defamation type lawsuits like that. Basically, telling the truth is an absolute defense to a defamation lawsuit, but you don't want to be sued in the first place. A lawsuit is much less likely if before you release the information, you tell the prospective new employer, I'm sorry, we don't release information on former employees, but if you send us a written authorization from that applicant to release that information to you, we'll go ahead and do it. In our book online, we have a couple of sample forms for that purpose. Also, train your supervisors to only put job-related documents into the personnel file. The personnel file is not a place for, people to grind their own personal axes against each other. Only job-related, documentable information should ever go into that, because if you put what amounts to, gossip or, unkind accusations or observations or remarks in there, unless it has to do with a grievance investigation file, if that information is released without authorization, that could lead to an invasion of privacy or intentional infliction of emotional distress lawsuit. And even if you end up winning, it would still be very expensive to defend against. So just be careful. Only documentable, fact-related, job-related information should ever go into a personnel file. Concerning searches, Texas law is very flexible for employers regarding the ability to search. So basically, an employer has the right to search its premises and anybody on the premises and anything that people bring onto the business premises. That's why, at some events, you'll go into an event location, like a music location or some kind of outdoor festival location, if it's allowed in the pandemic situation now, and you'll be asked to let somebody look into your knapsack or your purse or your briefcase or other belongings. That's because the owner or custodian of business premises has the right to inspect anybody and anything that comes onto the business premises. Now, there was a famous case. This is a landmark case, Kmart versus Trottie. All the way back in 1984, Kmart got in trouble because they were trying to investigate a pill for each problem, and they had a security team go through everybody's stuff. And this particular employee, Ms. Trottie, she had her dressing room locker, the break room locker, broken into basically by company hired security staff. They snipped the lock, they opened her purse, rifled through the contents, put it back very haphazardly, and then put the snipped lock, her own personal lock, back on the locker. She found out about it, and she felt her invasion had been her privacy had been invaded, and a jury agreed and awarded over $400,000 in damages for the invasion of privacy. As the court observed in there, they could have, Kmart could have searched that employee's locker and even purse without liability if they had just warned employees that they did not have a reasonable expectation of privacy in any company property or on the company premises or in, any office furniture or purses that they bring on or anything that they bring onto the workplace. They could have searched, but they needed to have let Ms. Trottie know beforehand that could be done. And then if she had stayed with the company, she would have effectively agreed to that policy. So it's recommended, if you're going to ever search, conduct workplace searches, then you should do so pursuant to a search policy. And there is a sample search policy in our book. The main idea for a search policy, let employees know that there's no reasonable expectation of privacy in whatever areas are going to be subject to searches. So let people know that, if they have a work locker or a work desk or a trunk or some kind of chest at the workplace, the company has the right to search through that to make sure that there's no improper things there, no contraband or illegal items or stolen items or anything like that. If employees don't want certain types of items to be found, maybe they shouldn't bring them to the work at all. And if you forewarn them by letting them know that the workplace is subject to search, then Texas law will support that. Sometimes the question comes up, can we use things like metal detectors and x-ray machines at workplace? And the answer is definitely yes. That's totally legal. Do it in conjunction with a search policy. Be very careful, though, if you find what look like suspicious or illegal items, don't handle them any further, particularly if it's something that's illegal to possess, like drugs, controlled substances, and so on. Call the authorities, let them handle it. They're professionals, they're trained, and try not to, handle those any further. Just let the authorities look into that. Concerning drug testing is a form of search. It's a search of a person, and Texas law is very supportive of employers' rights to conduct work-related drug testing. The law is also flexible on the federal side as well. This is especially the case with safety-sensitive positions. Any kind of drug testing is allowed under Texas law. Now, with government employees, like employees who work for public sector agencies, some additional legal issues apply, such as a property interest in their job and so on. They have to be given due process, and certain procedural safeguards need to be followed. Those do not apply in the private sector. But because of the expense and trouble associated with drug testing, or alcohol testing for that matter, it's best to not do it unless you have safety sensitive positions at stake. And it should be done only pursuant to a good drug testing policy. In our book, on our website, we have a sample drug test policy, drug-free workplace policy. We also have a sample drug test consent form, and those are recommended for any employer that wants to do drug or alcohol testing at the workplace. If somebody gets fired for failing a drug test, the employer would have to prove in the event of an unemployment claim that the employee somehow violated the employer's drug policy, and that's misconduct connected with the work that would cause them to be disqualified. As Elsa Ramos noted, the employer has the burden of proving misconduct. And so how do you do that in a drug testing case? Well, one of the things you have to prove is that y'all had a policy and that the employee had consented to the policy and to the test, and that the policy that the drug test was performed and found certain hazardous or prohibited substances and in a certain amount, and you have to prove that the chain of custody of that sample was observed and controlled at all times. And you can do that if you use a reputable drug testing lab that will keep good documentation like that for you. But you need to have a copy of the test results. That's one of the essential items of evidence. Sometimes the question comes up, well, what if we're prohibited by federal law? We have truck drivers or oil and gas pipeline workers or other DOT regulated employees, and it was a DOT drug test, and the DOT regulations say that we can't release the drug test results to anybody but the employee without written consent. It just so happens that the Department of Transportation regulations on the federal side allow an employer to release drug test results to any administrative agency that is dealing with a claim or a lawsuit arising from the drug test. And on the screen at the bottom, you see the federal regulation that specifically allows that. So don't miss that item of evidence in a TWC unemployment claim. That's something that TWC needs in order to overcome a claimant's sworn denial of drug use. Searches of telephones, that's done with monitoring of telephones. Federal and Texas law give an employer the right to monitor their own business phones in order to ensure that they are used for their intended purposes, business use, and so on. So if you're going to do that, have some kind of a policy letting employees know that their use of company phones may be monitored and inspected. Their phone calls may be recorded. And it's a good idea because sometimes you get calls from out of state where state laws in those other states give people particular rights if they're on a phone call to know in advance if the phone call is being recorded. Go ahead and have a message before the call goes through to a person that the call may be recorded for whatever purposes, and that if the person goes through with the call, that means that they have legally agreed for the recording to take place. Now, because of invasion of privacy issues, though, if you're monitoring your company telephones and you notice that somebody is discussing personal, private, intimate, embarrassing, confidential details about, their lives or the lives of others, that may be a violation of your business use policy for your phone system, but it's not something to keep listening to. Once you have established that a violation of the policy is taking place, document it, make a note of it, but don't listen further, because the more you listen, the more privacy-related details you know about somebody, the greater the danger is that somebody can accuse you later of releasing that information to unauthorized parties without any kind of legal justification, and that can get the company into trouble from a privacy standpoint. This is a court case that came up, is quite relevant in this regard. Basically, this court decision held that the Baylor Health Network, this particular hospital employer, had the legal right to monitor the employee's calls, particularly because there had been complaints about her personal use, excessive personal calls on the employer's business phones. And an employer has the right to do that. So this is a court decision, one of many in this regard. Talking about recording of conversations, this is something that is totally permitted. Under Texas law, you can record it as long as one party to the conversation knows it's being recorded. You can record it. That's something to keep in mind, though, when you're talking with your own employees. They might be recording you. So just be careful. If you're talking with an employee, a particularly troublesome conversation like a reprimand or a performance evaluation, if things aren't going all that well in the workplace, they may be recording you. So just basically assume that they are recording you and keep the conversation as job related and fact related as possible. Keep it on an even keel because what you say, if it's recorded, could easily come back to haunt the company later. Video surveillance. The rules for video surveillance are much the same as for telephone monitoring. Basically, if you're recording only video, you can put a video camera anywhere it would be legal for your eyes to be. Anywhere it would be legal for you to look at an employee doing something, you can put a video camera to do that looking for you. As long as it's only video, you don't have to let people know that the camera is there. But if you are recording audio as well as video, federal law would require the company to let the employees know that the monitoring is taking place and get their consent. That's easy to do. There's a sample form for that policy in the book. Just look at the section of the book called the A to Z of Personnel Policies. The sample forms and sample policies are kept in alphabetical order in the book. So just take a look at that and see if that might help your company in such a situation. If you get recordings of surveillance, if the surveillance shows people doing stupid stuff, bad stuff, embarrassing stuff, stuff that people have a right to confidentiality and privacy on, even though it might be a violation of company policy or even violation of a law, keep in mind that certain things like, private, confidential, intimate details should not be released haphazardly. It should never be an object of amusement at employee parties or anything like that. Only people who have a job-related need to know should ever look at those surveillance recordings. So just be very careful in that regard. If you have an unemployment claim based on something, a violation of policy that was caught on a video camera, make sure you preserve that evidence. You've got the right to release that to the TWC, and something that you ought to keep in mind as far as information you release to the TWC in connection with an unemployment claim or appeal. That information is completely confidential and it is not subject to the Open Records Act. Nobody but the claimant or the claimant's legal representative can get a copy of that. And you and your legal representative have a right to get a copy of whatever the claimant submits, but nobody else has a right to get that. So that's not subject to the Open Records Act. That's subject to an exemption from that. So go ahead and release surveillance tapes. That can help prove misconduct. Be careful with camera phones. Camera phones sometimes get companies in trouble because people do, extremely stupid and inadvisable things with them, like take photos, unauthorized photos of their coworkers in compromising situations or private or embarrassing situations. That can lead to hostile work environment claims and lawsuits or invasion of privacy lawsuits against the company. Make sure that employees understand that any kind of unauthorized, inappropriate use of personal electronic devices like that can lead to a complete ban, as far as they're concerned, of their use or possession of such devices in the workplace, as well as civil or criminal liability if they violate a law. So it's a very, very serious thing potentially. Electronic surveillance, that's a bigger issue all the time. Basically, just like with phone systems, employers have a complete right to complete freedom to monitor any and all usage by employees of the employer's electronic systems at work, email systems, internet, the company intranet, the company's internal computer network, any and all use of company computer systems and online and internet systems can be done by the company, but you need a good policy. This is just a short listing of the various ways that employees can get in trouble using company computers. And if a company does not carefully control this, even the company might be held liable for misuse if it knew or should have known that inappropriate stuff was going on, but it failed to take any reasonable action to stop it. So be careful. You need a good policy. Let employees know that they have no reasonable expectation of privacy in any of their use of the company's electronic resources, because the company owns it, the company provides it, the company pays for it, and it's to be used only for job-related purposes. And so anything they do on company computers can be monitored and recorded at any time. There is a sample policy on internet, email, and computer use on our website. It's in the book. Just look for it in alphabetical order in the A to Z of personnel policies. Define the computer systems as broadly as possible. Keep in mind that technology changes all the time. Different advancements are called different things. So be as flexible and broad as possible in the definitions. And feel free to update your policy and have employees sign for copies of the updated policies. And remind employees that not only might they lose their jobs if they do something in violation of the computer policy, if what they do is bad enough that it's actually prohibited by law or violates the rights of others, they may be subject to civil and criminal liability as well. And some things must be reported to law enforcement, such as any kind of access of illegal content on the internet. And just if you have any questions, you're welcome to contact our office. These are some of the top reasons to suspect internet abuse by employees. And some of y'all may recognize some of these things. You may have seen some of your employees doing these things, but just basically, companies have very good reason to be concerned. It's because sexual harassment and other type of harassment and discrimination claims and lawsuits can be based on electronic evidence. And so if you get claimed against or sued by an employee for discrimination, their attorney might tell y'all to put a freeze on all of your computer records and make the computers available for copying and analysis by plaintiff-friendly teams of people. You got to be concerned about what's on your computer system. That's why it pays to have a good policy and to monitor what is going on. The rules for email monitoring are much the same as for telephone monitoring. Basically, it's your email system, so you've got a right to monitor its usage, where it's going to be, used for company purposes. It's going to go out to other people from the company, and so the company has a right to control what goes out via email. If you find that people are violating your email policy by sending out personal, private, confidential, or even intimate details about themselves or others, just log the violation. Remember confidentiality and privacy rights. Keep copies only to the extent that you need it for personnel action purposes. Only people who have a job-related need to know should ever see that kind of email evidence. A common question is it legal for us to track vehicles via a global positioning satellite system, GPS technology? The answer is yes. Texas law totally allows that. A lot of companies with fleets of company vehicles commonly install GPS devices and do tracking and monitoring of the vehicle usage and the vehicle whereabouts and the paths that vehicles take during the day. All of that is completely legal, but let employees know that that's going on. It's a good idea because that will help you avoid any kind of unnecessary legal action from people who claim that they might have been unfairly surprised when they, claim that the company didn't notify them that the company was tracking their whereabouts while they were driving company trucks. Well, of course that's going to happen. If the technology exists, you can pretty well assume that it's going to be used. So just let employees know in a suitable policy about the GPS system. Medical information. Medical information probably has the highest degree of privacy protection. There are very strict regulations in place about the confidentiality of medical information on employees. That's not subject to any kind of open records release. It should never be released without a job-related need, without a legal justification to anybody. And HIPAA regulations put very strict penalties on unauthorized release of medical information in the context of doctor offices and hospitals and insurance providers. So be careful about that. It's a good idea to have a medical information policy, and there is a sample medical information policy in our book on our website. Basically let employees know, bottom line, don't be talking about the medical information of others. You don't have a right to gossip about other people. That's a toxic activity, and we're not going to tolerate it in our company. And let them know that not only can that cause the loss of your job, it can also bring about civil and criminal liability. And let employees know it will be dealt with. So don't tolerate that. That's a good idea for a zero tolerance policy. Don't be talking about the medical conditions of others behind their back unless they've given you special permission to do so. Don't be doing it. Concerning background checks, either in connection with the job application or employment, like considering somebody for promotion or transfer within the company, you can do background checks. Texas law allows it, the federal law allows it, but under the Fair Credit Reporting Act, if a company uses an outside for-profit firm to do a background check, certain formalities need to be observed. So number one, give the employee or the applicant clear notice that the check will be done and get their written authorization to do it. Sometimes the question comes up, we have an applicant, they're not authorizing us to do a background check. What can we do? Well, you can just let them know that you can't consider them any further for that position. You've got a right to insist on that as a condition of considering their application. So just be very careful to follow those formalities, but you've got the right to do the check. If the company decides not to hire somebody based on what comes up in the background check, the employee has a right to get a copy of that background check report and the name and contact information for whoever gave it. They've got a right to a reasonable amount of time, at least a week, to respond and maybe deal with it. If incorrect information is there, give them time to deal with that. Okay, so much for our the privacy talk, and now let me get into the other presentation that I want to give today. All right, and I'm going to continue sharing my screen here. Are you sure you want to share? Yes, and let's see. Okay, now. All right. Now, can everybody see my Payroll Tax 101 slide?
Yes.
I've got just a few minutes to cover some fundamental facts about payroll taxes from the TWC. First, a few words on the federal payroll tax side. Federal and Texas taxes are owed on wages, basically, wages from employment. They are not owed on payments made to independent contractors, people who are true independent contractors. But you know, as we're going to cover in some other topics in our Lunchtime Live seminars, webinars for the rest of the year, Independent contractors are an exception rather than the rule. Basically, if somebody's doing the work of your company and they're subject to your direction and control while they're doing the work of your company, they're going to be employees. They're not going to be independent contractors. It doesn't matter that they want to be independent contractors or your company wants to treat them as contract labor or something like that. If under the law they're your employees, then that's the way it'll be. There is no choice. That's not an option. So be very clear about who is an employee and who is an independent contractor. If they're your employee, you're going to be paying their wages. You're going to be reporting their wages to the TWC and the IRS, and you're going to be paying the IRS withholding tax, FICA and Medicare payroll taxes, and federal unemployment tax. In Texas, the only payroll tax is the state unemployment tax. That's owed to the TWC. Before you do anything else with an employee, job number one, you've got a new person coming on. What's the first thing that you get them to do? Well, besides, have exchange greetings, good morning, glad to see you and everything, get them to fill out and sign a W-4 form. You need that in order to properly and easily report their wages to the IRS. And also it helps with reporting wages to the TWC. You need that information on their full name and their social security number. Otherwise, it's very difficult to report wages to the IRS and the TWC if you don't have a proper name and a social security number. Do it before allowing the employee to work. This is not an option. If the employee says, oh, I'll fill it out later, no, you won't. You're going to fill it out right now. This is the biggest regret that companies have if they let people just start working and then the employee quits later and the company realizes they haven't gotten a W-4 on them. Things become very, very difficult. So don't let people start working until and unless they've filled out and signed a W-4 form. I recommend these publications for federal payroll taxes. The IRS.gov website has these publications for free. These are the links to find these publications. Publication 15, 15A, and 15B. Call the IRS for assistance. On the website, on this slide at the very top, you see the web address for their office index, the index to IRS offices around the country. It can be easier to call a local office than the national IRS office. They've got national phone numbers, but those are notoriously difficult to get people to answer. The federal unemployment tax is 6%. That's applied to the first $7,000 of an employee's wages in a calendar year, but you get a 90% discount if you operate in a state like Texas with a federally compliant unemployment system, and if you pay your state unemployment taxes properly, you can pay the federal unemployment tax at the rate of 0.6%. Which, with a $7,000 wage base, taxable wage base, 0.6% of that is going to be $42 per employee per year. Not too bad. The state unemployment tax is the only payroll tax in Texas. It's paid by employers. Employers pay the taxes, like Ms. Elsa Ramos noted. Employees do not pay the state unemployment tax. That's only for employers to pay. And the state unemployment tax rate is based on your claim experience, what chargebacks you have had. New employers pay at 2.70% during the first year and a half. The first 6 calendar quarters of operation, you have the new employer tax rate. 2.70% of the taxable wage base in Texas of $9,000 is $243. So during the first year and a half, your state unemployment tax will be $243 per employee per year. You pay the state unemployment tax again on the taxable wage base in Texas of $9,000, the first $9,000 that they earn during a calendar year. After the first 6 calendar quarters, you're eligible for an experience rating based on what unemployment claims you've had. If you don't have any chargebacks during the preceding 3 years, you're going to get the minimum tax rate, which is going to be the replenishment tax, which includes the 0.1% employment training investment assessment rate. So it's 2.70%. Really not too bad for new employers. And if you're operating at the minimum level because you're now experience rated and you've had no chargebacks in 3 years, you get just the replenishment tax. In 2020, that rate was 0.31%. Now, if you've had chargebacks, there's a complicated formula, and we don't have time to go into a lot of detail. This is the outline of the formula here. The central component is your benefit ratio, which is the total chargebacks you've had over the preceding 3 years divided by the total taxable wages that you've reported and paid taxes on to the TWC over the same 3-year period. That's the benefit ratio. If you have a high chargeback total, that's going to be a higher benefit ratio. You get a higher tax rate. If you have a lower chargeback total, you'll have a lower benefit ratio and a lower unemployment tax rate. Only wages on which you've already paid unemployment taxes can be used in that calculation, though. So you want to make sure that you've paid all of your state unemployment taxes to keep your rate as low as possible. To get the tax rate, you multiply the benefit ratio by the replenishment ratio to get the general tax rate. The general tax rate will have the replenishment tax added to it, plus a deficit tax if there's a deficit in the state unemployment trust fund. There might be a surplus credit in really good years with low unemployment rates. There might be an interest tax if Texas owes interest on a federal unemployment loan from the U.S. Department of Labor. That's not going to happen because the loans are interest-free this year due to the CARES Act. Also, in years that we are repaying bonds, there might be an obligation assessment tax. That won't happen for 2021. The effective unemployment tax is a result of all of those factors added together. Shortfalls in the Unemployment Insurance Trust Fund, those are recovered half through the replenishment tax and half through the replenishment ratio. There's a detailed illustration of the tax rate calculation formula at the web address that is shown on this slide. And it's really easy to find on the internet site. Just go to twc.texas.gov, click on Learn About Unemployment Taxes, and then you'll find a tax rate calculation formula explanation on that page. Publication of new unemployment tax rates for 2021. The 3-year look-back period ended yesterday. So for this next month, the tax department is going to get all of the wage and chargeback information needed to calculate the tax rate. In November, the calculations are going to be carried out. The information will be shared with the commissioners. The 3 commissioners will decide on what the replenishment tax should be. And if there's a deficit tax, they'll decide what the deficit tax should be. After the first week of December, the tax rate notices will be mailed out to all the private taxed employers in Texas. If you are an employer and you want to appeal your tax rate or any decision of the tax department, you can do so through Commission Rule 815.113. The information for how to do that is at that web address that's on the middle point of that slide. And it's something that the commissioners will act on. They will analyze each Rule 13 appeal, and the 3 commissioners will vote on the outcome. Okay, well, that's all that we have time for, unfortunately, but in any remaining time, I will be glad to answer any questions that come up. So let me end the show there, and let's see. The shared window. Stop sharing. All right. We're back to the main screen.
It is actually 1 o'clock, just about, so we will be wrapping up our webinar for the time being. We did receive a lot of questions before the webinar took place, and we answered many of those on a document that Tommy has put together, and it is available on several websites on Texas Workforce Commission web pages. Should be pretty easy to find, along with our prior recorded session. So if your question was not addressed, many of them were addressed today during the actual presentations, but we encourage you to reach out to our office should you have more inquiries. And of course, we will have another session on October 15th. That is our next webinar for Lunchtime Live. We encourage you to register. And that's it for today. We thank you so much for your time and take care.